country, they're not binding anyway. But they are incredibly important if you follow the formalities. Are they always binding, Dana, in Latvia?
Yes, they are always binding, and let me explain. So the agreements in Latvia can be signed in three forms. Either that's a private document signed by both parties, either there is notary approval on the signatures, or the third option is a notary act, and the nuptial agreements are always signed in a form of a notary act, which means that the notary has fully explained to the parties the contents and the consequences of the agreement, and to later to apply to the court and to ask to recognize null and void some part of the nuptial agreement is always close to zero. It is impossible, because that's a notary act. Of course, theoretically, there can be a case that notary made a crime and against the will of the parties issued such notary act, but that's a theory. In practice, it is absolutely impossible. As soon as we see that that's a nuptial agreement, we immediately explain to the clients that there is no chance in the court to recognize it null and void. But there's another thing. These nuptial agreements can be recognized null and void by the third persons. For instance, if the spouses have intentionally signed the nuptial agreement to avoid some credit obligations towards the third persons, then these third parties who are offended can possibly raise a claim against either one of the spouses, and in that way show that this nuptial agreement was concluded in bad faith to avoid financial obligations. Mostly we see that in insolvency cases, where insolvency administrators are raising claim at court against that unfaithful party. And there is such a non-written rule that nuptial agreements who are younger, newer than 3 years, are under the risk of these court proceedings. It is very rarely, but this risk can happen. So mostly if the spouses feel that financial negative consequences are coming to either one of them, they prefer not to conclude a nuptial agreement, but to make artificial divorce. They just divorce and they agree on separation of the property in a divorce process. That's more safe. Thank you.
How's that resonate with you, Diane?
Well, we've got some similarities to Latvia. Like it is binding because it is once the nuptial agreement, in this case, usually the matrimonial regime, if it's signed before the notary, then it is absolutely binding. Well, it's actually binding even if you don't sign it before the notary, when you have the matrimonial regime by default. But in case you replace for the matrimonial regime, it is absolutely binding because it is signed in front of the notary. You can't change that. But there's a big difference with Latvia. Our notaries do not explain the consequences. They may explain the content, but in a very basic way. Separation of assets, your assets are his and your other assets are hers. Okay, thank you. But no, it is much more to it, and they will not explain it. So yes, it's absolutely binding. Once you have signed this matrimonial regime in front of the notary, it is binding. But, well, they can be declared invalid. Not very often, but they can be declared invalid because the marriage articles are governed by the general rules governing contracts. This is a contract. So if there is a lack of consent, because there has been duress or error or intimidation, and you can prove it. I haven't seen many decisions. There are some decisions, but not many. Or as Dana said, the cause, for example, to commit a fraud against third parties in order not to pay a debt. Well, in that case, there wouldn't be a cause of the contract because the cause is a fraud. But you have to prove it, like everything else. And as you know, in Spain, everything that is not proved with a document is no evidence. We are document lovers.
And you, Lisa, is it always binding, or when is it?
No, I think we're more like England in this impact. But I do want to make a distinction between binding and enforceable. So it's not like Latvia or Spain that this document has powers because it was signed in front of a notary. And it's quite rare for documents to be signed in front of notary here unless they're sworn statements. But judges give significant deference to the contracts that parties have believed themselves to enter into. And what would normally happen here is that if a pre-marriage agreement or a marriage agreement was attacked in court, a judge will, there's a variety of different legal tests, and I'm not going to go through the specifics of the legal tests, but I can say as a general principle, if there has been full and robust disclosure, so that all of the assets and the debts are listed with accurate values. We just had an interesting case come out of our Court of Appeal quite recently where a fairly well-known politician did not fully and accurately disclose the value of the assets that he was trying to protect. And the agreement did get varied to pay his now former spouse more money. So full disclosure, accurate values, legal advice to both parties, and no duress. It's very likely that a court will uphold that. And there have been times where they haven't. I think that overall, court is looking to make sure that the application of the agreement at the time of separation is fair, not just fair when they signed it, but at the time of separation.
Yeah, that's pretty much identical to how it is for us.